let me very quickly remind you of what I think represents, therefore, the position today. And you will find conflicting judgments, but on a weight of authorities, this is what I think represents the position today, which is that prima facie, you will interpret a statute or a statutory provision according to its plain language, prima facie. But that prima facie approach, or that plain language, or that literalist approach can be departed from by looking at other aids to interpretation and other factors, such as by looking at the context in which that provision is found, by looking at the purpose, by looking at the mischief, and by looking at whether the literal or the prima facie plain language meaning would result in an absurdity or an anomaly. And if you cannot find any overwhelming reason to dislodge the plain language of a statute, then you must go with the plain language of the statute. So this is really the balancing position where, of course, you will assume that the intent of the legislature is borne out by its words, but that assumption is certainly rebuttable. If I can use another well-known legal analogy of rebuttable versus irrebuttable assumptions or presumptions. That's where we stand on the literal rule. Now, given that, therefore, context becomes very, very important, I wanted to start off today's part of the webinar by discussing judgments which explain and which, in the facts of those cases, in fact, turned the ultimate decision or approach to interpretation turned on the court looking at the context of that particular legislation and not merely the language of the section. And therefore, in this case, context becomes the determining factor. I thought that would be where I start off today. But before I actually analyze the Indian case law on context as a determining factor, let me, with reference to the note that I had circulated last time, let me just quickly read out from some of the celebrated English judgments on what is therefore the meaning of a context. What do we, when we say interpret a provision contextually, what are we referring to? And I think that the narrow view of context is the context that you can gather from the statute itself. That means you look at the preamble, you look at the statement of objects and reasons, and that's the narrow view of the context. It's really a context that is embedded in the statute itself. The wider view, or the more expansive view of what is context, really enables a court to dive deep into the legislative history, to trace the legislative history, to look at the enactments that preceded the enactment in question, and by tracing the legislative history, even by going outside the four corners of what may be revealed by the statement of objects and reason or by the preamble, would all constitute relevant context. So first, let's understand, therefore, what is context, and then we will go to the judgments that turned on an interpretation that I will call contextual, for want of a better phrase. In paragraph 11 of the note, I want to very quickly just read some of the quotations on what is context. If you'll see 11.2, this is on a quote from Benyon from Interpretation of Statutes. Context here is meant in its widest sense to include the context of the act as a whole and its legal, social, and historical context. This is subject to any rules as to the admissibility of external aids to construction. Statutory, this is an R versus Secretary of State. Statutory interpretation is an exercise which requires the court to identify the meaning borne by the words in question in the particular context. I'm not reading all of these quotations for you. You can read it for yourself. But what I do want to read is perhaps the most authoritative statement of what constitutes context. And this is something which is quoted in several later judgments. So let me go to paragraph 11.7 in Attorney General versus Prince of Hanover. And this is what Viscount Simons said. Words, and particularly general words, cannot be read in isolation. Their color and content are derived from their context. So it is that I conceive it to be my right and duty to examine every word of a statute in its context, and I use context in its widest sense, which I have already indicated as including not only other enacting provisions of the same statute, but its preamble, the existing state of the law, other statutes in para materia, and the mischief which I can by those and other legitimate means discern the statute was intended to remedy. So this is perhaps a very clear indication of what we mean by context. And I'll pause here for a second. You will recall that I had guarded against any doctrinaire approach to rules of interpretation. And this is perhaps why, because even when we are talking about contextual interpretation, you will find that the last part of this celebrated quote from Prince of Hanover talks about mischief being part of the context. So I think that everyone would be well advised to stay away from any rigid compartmentalization of these aids to interpretation. Now, keeping this in mind as being the meaning of context, let me then come to what I think are a couple of the Indian judgments, which, in my opinion, are very, very important for the purposes of explaining a good example of contextual interpretation. Now, the first judgment, which I must refer to when describing contextual interpretation, is the celebrated constitutional bench judgment in RMD Chamarbaugwalla's case of the Supreme Court in 1957 SCR 930. Now, this is a judgment of the Supreme Court that was best known for enunciating the constitutional doctrine of severability. Now, in enunciating this constitutional doctrine of severability, the Supreme Court was first confronted with a question. And the question was, what is the meaning to be given to a particular definition in that case? And that the definition in question was, so the judgment involved the interpretation of Section 2D of the Prize Competition Act. And therefore, before we actually go into the discussion, it would be worthwhile to look at the particular provision that fell for interpretation. And you will find that in the judgment itself, or for those of you who have received last time's note, you will find it in the note which was circulated on the summary of cases. The definition which I am going to read out for you is very wide. And I want to first contrast the width of the definition in its plain sense with how it ultimately came to be interpreted or construed by the court. Paragraph 2 of the judgment, or if you have the note, sets out the definition, and let me read it out. It says, the object of the legislation is as stated in the short title and in the preamble, which is to provide for the control and regulation of prize competition. Section 2D of the Act defines prize competition as meaning any competition, whether called a crossword prize competition, a missing word prize competition, a picture prize competition, or by any other name, in which prizes are offered for the solution of any puzzle based upon the building up, arrangement, combination, or permutation of letters, words, or figures. So this was an act which was enacted by the central government to regulate and control competitions in which prizes of this nature were being awarded as a result of the competition. Now, the argument that was made to challenge the constitutionality of this provision, which was made by none other than Mr. Palkiwala himself, Nani Palkiwala, was that if you look at the plain language of the provision, the definition of prize includes not just gambling, but it includes games of skill as well. And therefore, the entire constitutional challenge was that how can you regulate and control a game of skill by the same definition that also controls or regulates something which is not based on skill but based more on chance. And I'm not now getting into what was the extent of the regulation, but the regulations did provide for what was the maximum amount of prize that you could receive for winning a competition, for maintaining a register at every physical location. So the argument of Mr. Palkiwala was that all of these restrictions on prizes for games of skill are unconstitutional. But before deciding the question of whether or not it was unconstitutional, the first interpretative question that the Supreme Court had to answer was that is Mr. Palkiwala even correct in suggesting or in arguing that the definition of prize covers games of skill, or if you read the definition of prize in Section 2D of the Prize Competition Act, and you read it in the context of the earlier legislations which preceded the Prize Competition Act, would it not be more accurate to hold that the definition of prize, contrary to its plain language, actually covers only gambling or games of chance. So that was really where the question of contextual interpretation came in this judgment. And the Supreme Court, first in paragraph, is that it considers the literal rule of interpretation as set out by Maxwell, but in the same breath, it also considers the other relevant aids of interpretation without placing any primacy or hierarchy on the literal rule of interpretation. And that is really the first point that I want to make as part of our study of this subject. And that you will find from the middle of paragraph 6 towards the end of paragraph 6. Then, to best illustrate what I mean by contextual interpretation in the wide sense as explained by the House of Lords in Attorney General versus Prince of Hanover, you will find that in paragraph 7 of the judgment, what the Supreme Court does is that it embarks upon an exercise of understanding the legislative history which resulted in the enactment of a central act, namely the Price Competition Act. And you can read that from paragraph 6 to 9 or 7 to 9 in your own time. But this is really where I want to make a point. And I think the point is very important because of the judgment and the manner in which it uses contextual interpretation to interpret the language of Section 2D. What the judgment essentially does, and this is the Supreme Court Constitutional Bench, which stalwarts on the bench, is that it traces, literally traces, the lineage of the Price Competition Act. It says that the Price Competition Act is a central act. But what preceded the Price Competition Act? What preceded the Price Competition Act were various state legislations, including the state of Bombay at that time, which sought to regulate lotteries. And those lotteries were not just any lotteries. Those lotteries which were sought to be regulated by state acts were lotteries where the lotteries were being participated, or rather the people who were participating in lotteries were people who lived or resided in a particular state. But to avoid the payment of tax on the lottery, what the lottery operators did is that they moved the location of the lottery to another state. So therefore you had, as part of contextual interpretation, the Supreme Court going back to the earlier state legislations. It analyzed the earlier state legislations as being state legislations which were directly concerned with lotteries. Lotteries, as you know, are clearly games of chance. When those state legislations were challenged before the Bombay High Court, the Supreme Court said that the Bombay High Court described it as a game of chance or as gambling. Then what happened is that because it was difficult for states to regulate this form of gambling that traveled outside the boundaries or borders of states, many states made a representation to the central government that you please enact a central law under Article 252 of the Constitution and regulate prices under that new central law. And it is after considering this entire history and the resolutions passed by the state by which they ultimately said, let's have a central law. It is by looking at this entire legislative history that the Supreme Court then came to a contextual interpretation of the statute in question, and it held in paragraph 9 that prize as defined in the Central Act must necessarily mean a prize only for an activity which is based on chance or gambling, and prize cannot include a prize for an activity which is based on a game of skill. And the Supreme Court said one more thing as part of contextual interpretation. It says that the Central Act is an act which is intended to regulate and control prize competitions. So, although Section 2D does not use the word control, the statement of objects and reasons talks about regulating and control. And the Supreme Court said, as part of its analysis of context, that the word control is an unusual and an inapposite phrase to use if you are dealing with games of skill. But it is relevant and an appropriate expression to use if you're dealing with games of chance or with an activity that is gambling in character or nature. So, by looking at the word control, the Supreme Court ultimately said that we are going to now interpret Section 2D as a provision that applies only to a game of chance, but not to a game of skill. And they therefore rejected Mr. Palkhiwala's first submission that 2D includes even a game of skill. The latter part of the judgment then gets into the constitutional doctrine of severability and says that even if we interpret 2D to mean game of chance and game of skill, we can always sever the provision, and what we would do in that hypothetical situation is to treat as unconstitutional that part, the severed part, but to preserve or to uphold the part which does not violate part 3 of the Constitution. That's of course not the subject of today. I'm only completing what the judgment goes on to say, because it's a judgment well known for that principle. So that is a classic example of contextual interpretation. Another example, a celebrated example of contextual interpretation, which I'm not going to get into in too much detail, so I don't necessarily want to open the judgment, but it is part of last time's note, is in the case of Peerless versus Reserve Bank of India. Again here, I'll quickly run over this. So to make my point of contextual interpretation, back in the 70s and 80s, there were many financial schemes, and this was at a point of time when the financial markets were not anywhere near as regulated, or some might say over-regulated like they are today. But there were many financial schemes that were floated by companies that, for want of, at that time also, they would perhaps best be described as non-banking financial companies. They didn't have banking licenses. And these schemes were taken to rural areas. And perhaps the reason why these schemes became popular in rural areas is because the level of understanding or comprehension or gullibility was more amongst rural people who were less exposed. And many of these schemes were prize chit schemes where people were induced to contribute small sums of money with a promise that if ultimately they were to be successful, there would be a very substantial amount that was refunded to them. And it was this lure or this promise of a high chance of success and a substantial refund that led to many of these schemes causing tremendous economic hardship to poor people in rural areas. And therefore you had an enactment called the Prize Chits and Money Circulation Schemes Banning Act that was passed by Parliament. Now, why is this judgment a celebrated judgment for contextual interpretation? The definition of prize chits in this judgment does not actually, in its plain language, require there to be any prize. The definition of prize chits in 2E only requires there to have been a refund to a person of something more than what was initially contributed by that person. So what was central to the very name of the act, namely prize chits, did not actually appear to be a prominent feature in the definition of prize chits. And as Justice Jeevan Reddy put it, as Justice Chinnappa Reddy put it, was that could you extend this definition of prize chits to a prize-less chit? That means to a scheme where it was much simpler, that it was only a scheme that operated by which people made a deposit and received interest from a non-banking financial company. And again, the reason I cite this judgment, and this judgment has been cited in later judgments, is that after a very detailed analysis of the legislative history, the Supreme Court came to the conclusion that the definition of prize chits in section 2E would contextually and looking to the mischief have to be interpreted in a narrow sense and in a conjunctive sense, and it cannot apply as per its plain meaning merely in cases where there is a contribution which is made by a person and a refund received by that person, or a promise of a refund to be received by that person after a certain period of time. And what the Supreme Court said is that if this practice of making a contribution and receiving a refund is to be outlawed within the definition of a price chit, how is it any different from a simple deposit made with a bank or a financial company, albeit with those companies having a license? And it was really in this contextual manner that the Supreme Court, in paragraph 39, gave much more emphasis to the harmonious rules of interpretation and contextual rules of interpretation, and negatived the plain meaning or plain definition of 2E to conclude that it must be read narrowly and it cannot cover a priceless chit. Now, moving on with contextual rule of interpretation. The last judgment that I want to discuss squarely under this head is not so much a case involving interpretation, but it was a case in which the Supreme Court, a constitution bench of the Supreme Court, had the occasion to reconsider the challenge to the constitutional vires of section 377 of the Indian Penal Code. Now, before you read this, and I'm not really, let me rephrase that. I'm not going to ask you to read this, but I'm putting this up on my screen in case any of you want to read it. Let me give you a context or a background to this case. This is a case where unnatural carnal intercourse between consenting adults was held to be a crime within the meaning of section 377. It's popularly known as the LGBT case. You must understand that the background to this is that the Delhi High Court had held section 377 to be, in its, if applied in its plain sense even to consenting adults, the Delhi High Court held section 377 to be unconstitutional and therefore read it down to say that carnal intercourse between consenting adults cannot constitute a criminal offense. The state appealed that decision to the Supreme Court, and the Supreme Court reversed the Delhi High Court in what is perhaps one of the most regressive decisions of its time. The Supreme Court reversed the Delhi High Court, and in so reversing the Delhi High Court, held that section 377 as it stands is constitutionally valid, and the Supreme Court therefore said that any intercourse between two consenting adults that falls within the definition would constitute a criminal act. In other words, as far as society understood it, what the Supreme Court said was that the disposition to being gay in India constitutes a criminal act. And there was a huge uproar, as you can imagine. And that was a two-judge bench of the Supreme Court. The Supreme Court then had occasion to reconsider this issue because there was a referring judgment which said that the two-judge decision was per incuriam. And the Supreme Court had occasion to reconsider the two-judge decision, which it did in this constitution bench decision in Navtej Singh. Now, I'm not getting into the constitutional aspect of the matter or the constitutionality of 377, which is really a fascinating discussion, but not part of this webinar. What I am getting into is one discrete component of Justice Nariman's analysis of 377 or his contextual analysis of 377 in the Navtej Singh judgment. And this is where contextual interpretation has been applied in a most fascinating manner by Justice Nariman. What he did in his concurring opinion is that he traced the legislative history of section 377 to the drafts of the IPC that were prepared by Lord Macaulay, and the corresponding provisions in those drafts, which were in the form of clauses, were clauses 361 and 362. Now, what Justice Nariman then does in paragraph 272 of his concurring decision is to say that even over 100 years ago, during that very, very conservative, prudish Victorian era, Lord Macaulay gave due importance to the fact that the crime is as between two consenting adults. Because in the draft form prepared by Lord Macaulay, the maximum offense, the minimum offense if the crime was committed as between two consenting adults was 2 years. Whereas if it was a crime committed as between consenting and a non-consenting person, the minimum offense was 7 years. What Justice Nariman therefore does by tracing the legislative history is to conclude that even 150 years ago, the legislative history, which forms part of context, tells us and informs us that consent was an extremely relevant factor. Maybe consent was not relevant enough for making the act a non criminal act or for decriminalizing the act itself. But consent was certainly a relevant factor even 150 years ago when determining what would be the punishment for the crime. Now, although those clauses do not then find mention in the final text of the IPC or in the later drafts, Justice Nariman gives fair importance to that legislative history when he comes to the conclusion that you must, to save present Section 377 from its constitutional challenge, you must therefore read it down in a manner by which, if consent is there between two adults, it cannot constitute a criminal act. But that conclusion of Justice Nariman in giving importance to consent has its foundation and has its moorings in the legislative history or in the context that he traces back all the way to the drafts of Lord Macaulay. So I think that this is really a fascinating example, in my opinion, of how far and how deep and how innovative the use of context can be when reading a provision, interpreting a provision, or as in this case, when reading down a provision. So those are the judgments that I wanted to quickly cover as far as context is concerned.